Indeed.
SJC-12338, Commonwealth v. Adnan Tahlil.
Good morning, Mr. Chief Justices.
Wait,
Justices.
hang on one second till we get all set. All right, now, Mr. Zinni, good morning.
Thank you. Good morning, Mr. Chief Justice. Justices of the Supreme Judicial Court. I am Jack Zanini. I'm here on behalf of the people of the Commonwealth and the Suffolk County District Attorney. With me today is Trial ADA Alyssa Tochka. We're asking this court to exercise its supervisory power to correct a clear error of law that occurred in the Brighton Division of the Boston Municipal Court. I believe that the standard of review is de novo under the grand jury case at 470 Mass, page 400, because you're reviewing the assertion of a self-incrimination privilege.
Mr. Zinni, can I ask you on the exceptional circumstances part of this formulation, how do we weigh the fact that there apparently are still photographs from the video that exist that could be introduced into evidence, as well the witnesses to describe what they saw in the still photographs? Of course, I don't know the quality of the video nor the quality of the still photographs, but wouldn't that weigh to whether or not there's a need for your remedy?
I don't believe so, because I don't believe you can force the government or the court can pick and choose what the evidence is going to be. It's the government's burden, and whatever relevant probative material evidence is available, the government can put forth. This was not a balancing test.
Doesn't that go to the amount of prejudice the government is under if there is alternative evidence?
I don't think that 211.3 goes to prejudice. It goes to whether there's a substantive right violated. We have clearly a right to produce what evidence we have or can get legally that's not privileged to meet our burden of proof. This particular piece of evidence is absolutely critical because it is part of the res geste of the crime. It's a recording of this defendant and others in a store with the stolen card. They robbed and beat a man at 2:30 in the morning. They assaulted him. They took his wallet, his bank card, and his Brazilian passport, and they were using the bank card in the store. This is a recording of them in the store. The bank card was recovered in the store by the police.
I take it the pictures are excerpts from the video, right? They're just spliced.
They're stills, but they're not really that great. And when you see it's much more powerful and probative to a jury to watch a TV show, frankly, to watch the video. And critically, the victim was shown the video by the detective, and he identified the perpetrators, including this defendant, on that video.
But that comes in too, though, right? I assume that the identification and the circumstances surrounding the identification would come into evidence as an exception.
I believe so, but then
right?
you've got a missing piece of evidence, and so that's critically, unfair to the Commonwealth to deprive them of evidence for which there is no privilege. There's no self-incrimination privilege. This is not a testimonial statement of this defendant. It's simply not his statement. There's no attorney-client privilege. There's no confidentiality. This is not material produced to the attorney by the client. This was already known to the government, to the shopkeeper.
And that's how you would distinguish the Enrique grand jury from 2014 and the turning over of the cell phone, because that had an aspect of testimonial within it.
Right. Two critical components, the testimonial aspect and also the Fisher Doctrine. To have the Fisher Doctrine apply, it's got to be material that was produced by the client and given to the lawyer for legal advice. That's completely inapplicable here. So there's simply no legal basis to allow an attorney to take evidence, put it in his folder, take it back to his office, take it home, put it in his car, wherever the attorney wants to put it, and then not produce it at trial. And this would not delay the trial. The Commonwealth brought the case forward the day before the trial, orally asked for it to be produced to show to the jury. The judge didn't take action, said, I'm not taking action today on that, file a written motion. We did, and then when the written motion came in, the judge denied it.
No good comes out of a trial taking 4 years to get to trial. I think from arraignment to trial, it's 4 years.
I agree, it's inexcusable, but as we assert in the brief, and as the docket will show, much of the delay was based on defense counsel repeatedly asking for dates to go off and continuances and further proceedings. Part of the delay is due to the court system moving incredibly slowly, which is inexcusable. In the meanwhile, this defendant has been at liberty for a good chunk of time, but is now indicted for other crimes. So no good came of the delay here. But I think the real bottom line is you can't have lawyers secrete and hide evidence, take evidence, and not make it available at trial. That just casts the court system and lawyers into disrepute. And the court needs to send a clear message across the Commonwealth to all attorneys and all judges. This is not acceptable conduct. Unless the court has other questions.
All right, thank you.
Thank you.
Mr. Chapdelaine.
Good morning, Your Honors. Alex Hahn for Adnan Tahlil, here with Jeffrey Chapdelaine, who is trial counsel, who's in possession of the videotape. And I guess we do take a little bit of offense to the accusation of secreting evidence, particularly when I think the disciplinaries are very clear that this is confidential information, and it would have been gravely remiss for Attorney Chapdelaine to turn over this videotape without a court order.
Well, why is it confidential information? They provided you the information, so they've clearly seen it. It's not, it just seems artificial to describe this as confidential information, isn't it?
Well, whether it's confidential information in part turns on client consent. The rule contemplates, I think pretty specifically, first of all, the comment to the rule says that confidential information consists of information gained or during the representation of a client, whatever its source. So I think that whatever its source language is pretty critical. And then the rule itself, Your Honors, 1.6, a lawyer shall not reveal confidential information relating to the representation of a client unless the client gives informed consent. So this tape is only in the possession of defense counsel, and I think clearly this originates with the Commonwealth losing something. So we're here because evidence was lost.
All right, but
Would it
counsel,
make any
putting all that
difference?
aside for a moment, you know, the lawyers have to get along and get along civilly and be professional. And I understand that there is an issue that you might feel that you cannot give things back that you got from the Commonwealth because it might hurt your client, and too bad for them, they lost it. It seems to me basically your position. Is that right? You know, they lost it, so they have to suffer that consequence. And but don't the defense attorneys and the prosecutors do better when everybody just exchanges reciprocal discovery? And couldn't we now call this reciprocal discovery in your possession that ought to be turned over?
Well, Your Honor, the reciprocal discovery provisions have been interpreted, you know, I think most saliently in the Durham case in 2006, and that dealt with witness statements being turned over from one side to another, and I don't believe this court has gone further than that. So I think existing precedent would not speak at all definitively and would not speak at all to whether or not there'd be an obligation to turn over this DVD.
What if the ADA had said, listen, we only have one copy of this, we only have the original, a little bit worried about potentially tampering with it if I were to attempt to copy it. I'm going to just lend you a copy, you can listen to it, show it to your client. In that situation, would you say you wouldn't have to give it back?
Your Honor, if you're positing, Chief Justice Gantz, if there were another copy?
No, let's assume there's only one copy, and for whatever reason, as opposed to making a copy, she were to say, listen, I'm going to just give you the original so that you can review it, and when you're finished reviewing it, give it back so I can use it at trial. Would it be your view that you would say, gotcha?
Well, I think, you know, there again, the turning over of the tape would have an authenticating quality, and it sort of implicates counsel in the production of the tape. There's clearly in the record some question about the functionality of the tape. So under the circumstances as we have them, the tape is turned over, and then if it doesn't work, the Commonwealth going to call trial counsel as a witness to authenticate the tape. So I do think it gets us into a bit of a morass.
Well, wouldn't counsel only have to authenticate it, or if the trial counsel objected, but if the trial counsel knows that it's not working and turned it away, why would they object to it? There'd be no need to authenticate it, right?
If it were not working, Your Honor? Well, I guess the question is whether or not it
It's
is.
up to you whether it needs to be authenticated.
There is ambiguity to whether or not it works. I mean, that's essentially the problem here. I think that
It's authenticated by the witness, not by the lawyer. So the tape is shown, and the witness says, yeah, that's the tape I saw in the system. There's a chain of custody issue, which goes to weight, but that's a pig in a poke. There's no authenticity issue here.
Well, I'm relying in part on, I believe it was the Gelfglatt case, Your Honor, that says that making a statement about a particular piece of evidence, turning it over makes a statement about sort of when and where it is and does function as an authentication.
That's a different situation, because if the attorney is turning it over, there's a statement implicit in that of where it came from in that particular case. But here, just as Gaziano's pointing out, there's no authentication issue. It's not even, that's the tape I saw, that's the events I was involved in. So I don't really understand the productivity of that argument. But I guess I just would like for a moment to go back to Justice Cipher's point, which is, you know, you're looking at this tape to get ready for trial. It's evidence in the case. What possible argument is there that, well, I think we'll just keep the evidence that you gave us because we don't want to turn it over. It's not confidential. I mean, honestly, what possible argument is there?
Well, I think there's a number of arguments, Your Honor, that
Are they the ones in your brief?
essentially the arguments, we have presented the arguments in the brief, and I'd be happy to amplify them. The Fifth Amendment and the Article 12 provision, and again, I great respect to the court in positing this as a relatively simple matter, but there are these obligations of counsel, as were found by Judge Shoptees, and also the facial language of Article 12, which says no one shall be required to accuse oneself or furnish evidence. And I think just facially that applies so clearly, Your Honors, that this is incriminating.
Does that apply also to the witness list before trial?
Well, the Durham case expressly deals with that, and construing the reciprocal discovery obligations. And so, yes, you turn over a witness list. Yes, you turn over statements.
But isn't that a violation of Article 12 under your reasoning?
It's not, because this court found it's not.
Were we wrong?
I would not say the court was wrong at all, Your Honor, in the Durham case. I would simply say that it does not apply in this context. And particularly, I think this case is about the superintendents.
Can I ask, I still don't understand your response to the chief's question. Yeah. Are you not allowed to produce that too? Once they've given it to you, is it gone? I'm confused by your answer to that. Because that can't be right?
Just to make sure I'm following the question in terms of the tape being produced and an obligation to give it back.
They hand you the original, and you've got the original, and there's only one version of it. Once you've got it, they don't get it back under your analysis? I'm just trying to make sure I understand your answer.
I believe that's true, Justice.
Really? That can't make any sense, can it?
Well, it made sense to the trial judge and also to the single justice.
I'm asking about the chief's question. If they give you the original because they're concerned about copying it or somehow damaging it, once you have it, I take it under your view, you can't give it back.
If there's only one copy, that is the position we're taking.
And if there were multiple copies, could you give back the original if they needed it?
In either case, I think that the same considerations that troubled the trial judge who wrote the 15-paragraph opinion and the single justice would still apply. I mean, we are left with the law as it exists before us, and we the judge applied that law, and we
No,
think.
I have to tell you, I read your brief.
Yes, Your Honor.
And I have a hard time really grasping your argument in a way that is consistent with my understanding of the adversarial process as we've come to know it and practice it in terms of no surprises, no trials by ambush, reciprocal discovery. And, you know, this kind of discovery dispute is not something we would normally see between criminal attorneys. Sometimes you might see it, no offense to anybody, on the civil side. But this is not the kind of spat we usually see, because there's a respect for each other and a respect for all the rules and a reality that they had it and they gave it to you. And you should, you know, I need to be more persuaded.
Yes, and there's no intent at all to be acrimonious in not turning this over, Your Honors. I mean, we think that the disciplinary rule is quite clear, evidence from whatever source, and the right against self-incrimination.
You actually think you're going to get disciplined for giving that document back?
I think a client is going to be extremely troubled by this sequence of events in terms of the Commonwealth losing evidence and the defense counsel turning it over. I think it would be inflammatory and effectively lacerating.
Oh, do you perceive any issue between a conflict with your representation duties to your client and your ethical obligations under the bar? Is there a conflict in that should have been brought to a judge to say, help me with this, give me an order?
Well, I think it was addressed fairly thoughtfully by Judge Shoptees, and I don't believe there'd be any obligation beyond that. We had
because if it's just a matter of your client being upset, I don't mean just, but I know that, I mean, that happens all the time. Clients are upset. But an order would protect you from a judge saying, you know, you better give it over. It wouldn't be your fault then, would it?
Well, and if Judge Shoptees had ruled the other way on this, I think, you know, obviously that concern would be vitiated. But when the ruling goes our way, you know, obviously it's not going to be turned over. But I do think I would be, Attorney Chapdelaine made that decision, and I would make absolutely no different decision, Your Honor, not at all in the spirit of thwarting justice, but based on the plain text of the rules. And I do think this case goes to the supervisory function. I see that I'm out of time, and I'll rest on the brief unless there's further questions.
All right, thank you.
Thank you, Your Honors.